All right, folks, welcome back. We apologize for the break in transmission that is due to network connectivity issues. So please let us know the quality of the audio. We're live here from the grounds of the Temple of Justice. We're getting more fresh updates coming in from the Criminal Court A. The petitioner's request for Judge Roosevelt Willie to quash a subpoena issued by the Asset Recovery and Property Retrieval Task Force to the Clar Hope Foundation to provide documents pertaining to the construction, establishment, and operations of the Clar Hope Foundation. That foundation is contending that the AREPT lacks the legal jurisdiction. Now, these are updates coming in, real-time live updates coming from Criminal Court A. So Judge Roosevelt Willie have said that the Asset Recovery and Property Retrieval Task Force subpoenaed 3 institutions and the Clar Hope Foundation is the 4th, and that they are the only ones that said they cannot comply. So out of 4 institutions that were subpoenaed by the Asset Recovery and Property Retrieval Task Force, only the Clar Hope Foundation has said they cannot comply. The institutions are the management of BMC, the Rural and Renewable Energy, and Soft Solar, etc. So the investigation subpoena establishes a chain of an ongoing investigation. So what we've been told is that Clar Hope Foundation is 1 out of 4 institutions subpoenaed by the Asset Recovery and Property Retrieval Task Force that has failed to comply. Now, according to the judge, this subpoena of the other 3, including Clar Foundation, is to show that there is an ongoing investigation. According to the judge, the other institutions fully cooperated and the court can produce their documents. They cooperated, they produced their documents with the exception of the Clar Hope Foundation, for which the judge says is not acceptable. According to Judge Roosevelt Willie, the refusal of the Clar Hope Foundation to comply to the subpoena and provide documents is not acceptable. According to the judge, it is disobedience, and if a subpoena is issued by the court for any institution and it risks being held in contempt. So the judge said that the management of BMC and others complied and provided everything required. Only the Clar Hope Foundation have said they cannot comply to the subpoena. So we'll be bringing you more updates. Just a recap of what is unfolding. The Judge Roosevelt Willie, presiding circuit judge here at Criminal Court A, Montserrado County, is reading his ruling in the petitioner's request for a motion to quash the subpoena issued by AREPT. They are challenging the jurisdiction of AREPT in this matter. Now, the judge, if I can just paraphrase, have said that, look, Clar Hope Foundation, 4 institutions, including you, were subpoenaed. 3 of those institutions, namely BMC, Renewable Energies, and Solar Corporation, they all provided their documents. Why are you refusing to provide your documents? If the subpoena comes from a court of competent jurisdiction, you are under obligation to comply. You not complying, your lack of compliance shows disobedience to this court, to the court, and hence you risk being held in contempt. And talking about contempt, we just had a famous contempt hearing here, a famous contempt trial that has now gone down in the history books, and that was with Prophet Key. He's in no way, connected to this matter, but just that the word contempt is being used again. And this time around, it is direct contempt because it is happening within the court. You were issued a court subpoena as part of the court proceedings, and you have failed to comply, according to Judge Roosevelt Willie, from the information that we're getting in a very quiet courthouse, and only the judge's voice is being heard. That why is Clar Hope Foundation refusing to provide documents? That these documents are in line. The chain shows that there is an ongoing investigation, and their refusal to honor the subpoena is tantamount to being held in contempt. The risks being held in contempt. So the judge further stated that the management of the Building Materials Center, BMC, which is the company that carried out the construction of the Clar City of Hope, has complied and provided all requisite documents to the Asset Recovery and Property Retrieval Task Force, and all others have complied and provided everything requested for by the Asset Recovery and Property Retrieval Task Force. So Judge Willie is still reading, and so far we cannot tell what the outcome, what the ruling will be, whether the judge is going to grant the petitioner's motion or the judge is going to deny the petitioner's motion and rule in favor of the respondents. And this time the respondents are the Asset Recovery and Property Retrieval Task Force by and through its head, Councillor Edwin Clarmontin, and others associated thereof with that institution. We're about to give you more updates, but so far this is what is unfolding in the court. 4 institutions subpoenaed, namely BMC, Rural and Renewable Energy, Soft Solar, and Clar Hope Foundation. 3 out of 4 complied with the subpoena, provided the requisite documents as requested. Only the Clar Hope Foundation refused to comply. They used the legal remedies available to them by running to the court, praying a petition for that motion to quash the subpoena on grounds that the AREPT lacked the jurisdiction. The judge is ruling in that matter. So we are waiting for more updates. Bear with us. What we are experiencing is a slow strength of internet connectivity. The speed of the internet is slow, so hence updates are trickling in at a snail's pace. That is way beyond our control, but we will do our best to bring you real-time updates from within Criminal Court A. The foundation of the former First Lady of the Republic of Liberia, the Clar Hope Foundation, mainly and namely the Clar City of Hope, is what is under scrutiny at this moment. So stay with us. So the judge has said that the issue raised to quash the subpoena cannot be possible because the Supreme Court has already passed on why a subpoena should be issued. So this is a sting in the tail. So Judge Roosevelt Zerwilli have said that he cannot quash the motion. He cannot quash the subpoena. He cannot quash the subpoena because the Supreme Court has already ruled on the reasons why a subpoena should be issued. So I'll read that again. The judge has said that the issue raised to quash the subpoena cannot be possible because the Supreme Court has already passed on why a subpoena should be issued. So we're waiting to get the final ruling, the final statement for the end of this ruling from Judge Roosevelt Zerwilli. But the trend that is taking now, because the Clar Hope Foundation challenged the jurisdiction of AREPT and the subpoena, and the judge is saying that it is not possible to quash the subpoena because the Supreme Court has already ruled on why subpoena is issued, why subpoenas should be issued. According to the judge earlier, from transcripts that we get in from the court, the judge has said that if 3 out of 4 institutions in line of this chain of investigations submitted the requisite documents as subpoenaed, why is Clar Hope Foundation the only institution refusing? Secondly, the judge said the refusal to honor a subpoena by a court of competent jurisdiction, issued by a court of competent jurisdiction, risks leading to contempt, and the foundation risks being held in contempt. That 3 out of 4 institutions complied, and why are they not complying? And it is challenging the authority of the court. So the last update that I've gotten says that the judge has said that the issues raised to quash the subpoena is not possible. It cannot be possible because the Supreme Court of Liberia, yes, the court just above my right shoulder, has already passed on why a subpoena should be issued. So we're waiting for more fresh updates. As I said, bear with us. We have a slow speed of the internet around this area today. We're experiencing that. It led to the shutdown of our earlier broadcast, but we're back up and running. But it is the Clar Hope Foundation, who are the petitioners in this matter, they are praying the court for a motion to quash the jurisdiction, a subpoena issued by AREPT on grounds of jurisdiction. So we're waiting for more updates. We are awaiting. Bear with us. It's quiet here. We can hear some groans as we are providing these updates, as folks all around here, those who are not in court, watching and listening to Spoon Network, getting the updates. Even those who are not watching but can hear me stating what's happening in the court. Conversations are ensuing between individuals. The police still present here, but they involved in their chit chats. It's quiet. It's not a very tense situation happening here. If it's tense, then that tense is in the courtroom. That feeling is rather in the courtroom. It's quiet, according to our correspondent, our senior judicial correspondent. It's quiet in the court that even if you drop a pin, you might probably hear the echo of that pin being dropped. Everybody's listening, and only the voice of the resident circuit judge, the presiding judge of the Criminal Court A, is being heard. So the judge has furthered that asset recovery as a legal body has the right to request documents from any institution through the court. So Judge Roosevelt Willie have said that Asset Recovery and Property Retrieval Task Force as a legal body, remember, the legality of the Asset Recovery Task Force was upheld by a ruling from the Supreme Court in the Gracious Right versus the AREPT, saga that we had lingering on for 8 months. The judge have said that Asset Recovery as a legal body has the right to request documents from any institution through a court. With the trend of what is happening, we cannot deduce what the outcome will be, but from your own reasonable reasoning and from the trend of what the judge is saying, we will hold and wait for the final words, whether the judge will say, I deny the motion, or I grant the motion, and I've also ruled and quashed the subpoena. But the last update coming from the court says that Judge Roosevelt Willie have said that the Asset Recovery and Property Retrieval Task Force as a legal body has the right to request documents from any institution within the bailiwick of Liberia through the court. Where is this leading to? We will find out at the end of the day. That's the reason we are here, to provide you all of the updates. The updates are coming in slow, but it's better slow and sure than not to get any updates as well. And this is what we do here at the Spoon Network. We provide you prompt information, real-time information as it unfolds, and we hear again at the temple of justice. This is a pivotal ruling. Either way that this ruling goes, it's either going to strengthen the resolve of the Asset Recovery and Property Retrieval Task Force and further the investigation into the Clar Hope Foundation and the Clar City of Hope, or is going to put a complete stop to that. I see a vehicle that looks like, okay, it's not from AREPT. It's not from AREPT. It's a debt recovery from a private institution. But I thought that was a vehicle. So we're waiting for more updates. More updates, folks. Keep following us. Diamond Slanger. I'm here with Gabriel Sagacia's Bar. Emmanuel Phillips is here. Jurassic Joe, our director of television, is making sure that we have all of the images and all of the audio coming in crystal clear for you to listen to, and keep updating us on the quality of the image as well. So we will provide you all of what is happening. But the latest update from the court as of current time is that the Judge Roosevelt Willie, has said that the Asset Recovery Task Force is a legal body and has the right to request documents from any institution through the court. He also said earlier that 4 institutions, namely BMC, Rural and Renewable Energy, Soft Cola, and the Clar Hope Foundation, were subpoenaed. 3 out of the 4 submitted all of the requisite documents, and only the Clar Hope Foundation has reneged or has refused to provide the documents. The judge further stated that refusal is also challenging the authority of the court, and that the institution, the Clar Hope Foundation, risks being held in contempt. The judge further said that why the three complied and only Clar Hope Foundation has refused to comply, and that these documents and court records shows that this is a chain of an ongoing investigation, and that he cannot grant the motion to quash the subpoena because the Supreme Court had already ruled on why subpoenas are issued. Now, the judge also stated that the Asset Recovery and Property Retrieval Task Force is a legal body, and so they can request documents from any institution in Liberia through the court. So we're waiting for more updates to give you, but once we get those updates, we'll read them to you. This is not the end of the road. If the judge rules in favor of the asset recovery and grants that the subpoena be responded to and all documents be provided, there's also a remedy, appellate remedy available to the Clar Hope Foundation. They can go to the Supreme Court to challenge the jurisdiction of AREPT. Now, the court has said that the raid is not directed to the former First Lady, but rather the foundation through its general manager. So those that are saying that, look, they've asked the former First Lady, Madam Clar Mariwia, to come and provide evidence, or the judge is saying that the raid is not directed to her. The subpoena is not directed to her. It's rather directed to the foundation through its general manager. So it is not Mariwia that is the subject of the raid or the subpoena. It is the foundation by and through its general manager. Remember, when you establish any institution or any corporation in Liberia, one of the rights is the right to sue and a right to be sued. So corporations, institutions legally registered and incorporated in Liberia can be brought to court, and they can also take other corporations, other institutions to court as well. So according to the judge, the raid or the subpoena is not directed at the former First Lady, but rather the foundation through its general manager. Will the judge grant the petitioner's request to quash the motion, to quash the subpoena, or will Judge Roosevelt Zerwilli deny the petitioner's request? That question can only be answered at the end of the day, and that is why we're here. I take a short breather, folks. I will be updating you from behind the camera for a minute as we provide you more updates here from Criminal Court A at the Temple of Justice. In the courtroom, we have the Senator of Margibi County, Nathaniel Fallow Magio, Chairman Emeritus of the CDC, one-time Minister of State for Presidential Affairs, currently the Senator of Margibi County, a close compatriot of the former president, and of course, the former First Ladies in the court. We have Councillor Jonathan Masakwe. He is part of the legal representation. We also have the former head of NOCAL, Safua Gray, Councillor. She's in court representation. And the state is represented by and through asset recovery. They're in court there. We are still waiting for more updates. The latest update from within Criminal Court A is that the court has said that the raid is not directed to the former First Lady, Clar Wia, but rather the foundation through its general manager. So it is the management of the Clar Hope Foundation that manages the Clar City of Hope to provide all of the documents through the subpoena. These documents include donors list, financial transactions, contracts, and the like. Keep watching Spoon TV. We're live from the Temple of Justice, bringing you live happenings. We are going to be slow in bringing you real-time updates because of the network connectivity issue. For some reason today it's really slow here, but we'll be doing our best to provide you with the needed information. Melvin Jackson is positioned in Criminal Code A for us. He has been providing us with all of the updates thus far. So I will read to you all of the updates from the first update that we got, that the ruling began at 10:30 a.m. rather than 10 o'clock. Representations present. Judge Willie started reading that the asset recovery had subpoenaed 3 institutions, and those institutions complied. The Clar Hope Foundation is the 4th institution subpoenaed by AREPT in what the court has. All of the previous 3 in the Clar Hope Foundation are somewhat linked, so hence those 4 institutions were subpoenaed according to the judge. 3 out of the 4 institutions complied with the subpoena and provided the needed and requested documents. Those institutions include the management of DNC, the management of Zero and Renewable Energy, and the management of Solar Company. Then the judge said that the refusal of the Clar Hope Foundation to honor the subpoena and provide those documents is also challenging the authority of the court and risks being held in contempt. The judge questioned why they chose not to comply. So please let us know the quality of the audio information that we provide you crystal clear audio. The judge said that the issue of Quash subpoena cannot be sustained. It's not possible because Alright. So let us know the quality of the audio, please. Let us know the quality of the audio if it's not good, so that we can tweak it. Please let us know the quality of the audio as we working. So please let us know the quality of the audio if it's good. Just send us a comment. Yeah. I'm coming from Magla Afun, so let so don't look for that. Okay, folks, please let us know the quality of the audio. Is it good now? If it's good, just kind of leave a comment. These are gadgets. You do your best to plan, and then sometimes they just have their own issues. So please let us know the quality of the audio. If the audio is good, just let us know the quality of the audio. Please let us know the quality of the audio as our technical guys are listening in. But it's loud. But we start to see, you expect to get breeze. Yeah. Alright, so just kind of let us know the quality of the audio. We are doing our best to work on the sound. Yeah, so kind of leave a comment and let us know the quality of the audio. Once the audio quality is good, we will continue. We've been getting updates from the court, and we will be providing you the latest updates as they come in. My name is Diamond Slanger. I'm here with Jurassic Joe, Gabriel Barr, and the rest of the guys. So once the sound is good, we're listening to the sound, and it's perfect now. Thank you for your continuous updates. Now let's go back to the courtroom. So the judge has said that the issue of invoking Article 21 of the Constitution cannot hold water because the asset recovery has the mandate to do so. So what is Article 21 of the Liberian Constitution? Let me get that quickly. Let me pull up Article 21 for you, and we can read Article 21 of the 1986 Constitution of Liberia. Remember, the judge had earlier said that the asset recovery is a legal entity. So Article 21 says fundamental due process protections. Article 21, prohibition of retroactive laws, bills of attainder, and ex post facto laws. So the government cannot punish someone for an act that was not a crime at the time of when it was committed. So the judge has said Article 21 cannot be invoked in this case. 21B, search warrants issued only upon probable cause. Warrants must be specific about the place to be searched and the items to be seized, the right to be informed on charges, and the right to remain silent, the right to bail and protection. So Article 21 takes talks about a whole lot of things, and the judge has said that Article 21 cannot be invoked in this particular motion or in this particular petition because the Asset Recovery and Property Retrieval Task Force has got the mandate to do what exactly they are currently carrying out. So far, all of what we've been hearing from Judge Roosevelt Willie, according to what is being transcribed to us, is that Asset Recovery and Property Retrieval Task Force is a legal institution. They can subpoena, they can request for information from any institution in Liberia through the courts, and that 4 institutions were subpoenaed. Out of the 4, 3 complied. Only the Clar Hope Foundation has refused to comply, and the judge stated that the rigs being held in contempt. According to Judge Willie, from what we have been getting, is that he also said that the issue raised to quash the subpoena cannot be made. It is not possible because the Supreme Court has already issued passed a ruling, an opinion on why subpoenas should be issued. The judge further stated that the Asset Recovery and Property Retrieval Task Force is a legal body, and hence they can request or ask for information from any institution in Liberia through the court. The judge said that the rate also is not directed directly at the former First Lady, because it is going through the Clar Hope Foundation through its management. So the judge in the latest ruling said that evoking Article 21 of the Constitution cannot hold water because the Asset Recovery and Property Retrieval Task Force has got the mandate to do what they are doing, the mandate to request a subpoena through a court and serve that subpoena on any subject of an investigation. Trying to get you more updates. Keep updating us on the quality of the audio as well as we strive to bring you real-time information from within Criminal Court A here at the Temple of Justice on Capitol Hill. My name is Diamond Slanger. What is unfolding is the judge, His Honor Roosevelt Zerwillie, is ruling in a petition filed by and through the management of the Clar Hope Foundation, who are the petitioners against the jurisdiction power, according to their rate, according to their petition, is that the Asset Recovery and Property Retrieval Task Force lacks the jurisdiction to have served them a subpoena, to have asked for a subpoena for them to provide documents, very crucial documents that include 1. Donors list, 2. Financial transactions, 3. Contracts, and the intent is to uncover whether or not public resources were used in the establishment, construction, and operations of the Clar Hope Foundation, by extension the Clar City of Hope there in Marshall City. So we are trying to bring you more updates. Remember, as I said earlier, bear with us. The network connection here is a bit slow today. We're doing our best to give you more updates in real time. That's what we do here at the Spoon Network. The sun is gradually coming up as compared to what we had earlier this morning. We were enjoying the good breeze from the ocean that is just right next to us, but that seemed to be going away from us. That luxury seemed to be going away from us. We're now feeling the scorching sun and heat, but that doesn't deter us from doing what we ought to do. What we can tell you is the courtroom is still quiet, according to Melvin Jackson, as he's reporting in real time that the courtroom is very quiet. The judge is still reading the ruling, and so far what we can tell you that has been read is what we've been providing to you. We'll go over the previous statements made by His Honor Judge Roosevelt Zerwillie of Criminal Court A here in Monserrado County, and this is a recap. 4 institutions were subpoenaed. We see Senator McGill has exited the court. Let's see if we can get quick words from him as he's here. Senator, yeah, we know we're still waiting for the ruling, but why are you here, sir? Why do you find it to be here?
I just wanted to follow the ruling to know what the court was saying. But the court hasn't ruled yet, so I can make a comment.
Yeah, going like halfway by.
Yeah, but I got to rush to work. I got to rush to work. I thought it was just going to be a 30-minute ruling.
But you've been listening to statements by the judge. What do you think it is? He said the Asset Recovery has got the authority, their legal body, and the rest. What do you think it is headed to?
No, the judge has not said that yet. The judge is just reading the position of each of the the lawyers. What the judge is reading are asset declaration, the asset for own position, and they read the defense, the respondent position. So the judge haven't made any ruling, so I can't make a comment.
What does this mean for the get a hint to where he's leaning?
I don't know. The judge can read aloud and make a final ruling, but after the ruling, I'll make a comment.
Are you here representing the CDC or yourself as a person?
No, I'm the chair of the CDC caucus. I'm a senator of Liberia. I have interest in the case.
No, my question is if you're here representing the CDC or yourself.
I'm not sure CDC, but I have interest in the case.
What interest have you in the case?
I'm a Liberian citizen. I'm a senator. Also have interest in the case.
Do you think they're coming one step too closer to the former president?
Let the ruling come. I'll make a position statement after the ruling.
Okay, so he's careful with his words. The Margibi Senator, Nathaniel Fallow McGill, former Minister of State for Presidential Affairs, now Senator of Margibi County, being very careful, very measured with his words as to where it is headed as of this moment. According to him, he thought this was just going to be a brief, ruling, but it has lasted beyond the time that he had allotted. So he's making his way to work. Well, whether or not he has chosen not to sound excited or anything, but the body language of the senator, his tone and everything sounds more hopeful, than more resolved. By the end of the day, we will be bringing you all of what is unfolding in the court. We will be bringing to you what is all unfolding, and we can tell you for sure that the ruling has not been handed down. That is for sure. The judge has not ruled in this petition. He has not granted the motion or denied the motion. That is far from what is unfolding. We're still reading you transcripts of what is happening in Criminal Court A. He has not handed down his ruling, and as I said earlier on, we cannot predetermine what the ruling of the judge will be. The judge could either grant the motion or deny the motion, but one of those two must be done today, and depending on what the ruling will be, we'll see what the next course of action would be. So it's a lengthy process. I can tell you for sure it's not a quick in, quick out process. It's going to take some time, and as I said, we are doing our best to give you more updates. Senator McGill has left the building. He's left the grounds of the Temple of Justice. According to him, he's making his way to work. Just next door is the Capitol building. Well, we will be trying to give you more updates as well. Folks, keep watching Spoon TV. We remain live here. You should bear with us that we'll have breaks and pauses, stepping away from the lens of the camera, but we will be providing you updates as to what is unfolding in Criminal Court A. It's not a crowded court ground this Tuesday morning. Heading to the afternoon, we've got approximately 12 minutes to 12 midday in Liberia. It's not a crowded court ground as compared to when we were here a couple of weeks back for the contempt hearing of Prophet Key. It is not that as it is, but we will be trying our best to provide you all of the updates. We will be trying to provide you all of the updates as we can get those updates for you. So we're waiting on more updates, folks. Trying to get you more updates as compared to still just providing you out of court analysis, but the updates are, slower in coming than what we started, and that because of the the network connectivity issue. But we will be doing a recap on what has been unfolding in the court. You know, earlier we announced that the Margibi County Senator Nathaniel Fallow McGill was in court. He has left the courtroom. According to him, he needs to go to work and do the people of Margibi, the job for the people of Margibi County that he was elected to do. So he has left the grounds. Question him about where he thinks this ruling will lean, or where would the ruling fall, or what will be the ruling of the judge. And he said, well, it's still far-fetched to give a definitive position. Judges might say one thing in prior to making their pronouncement, and once they give the actual ruling, you know, it might be different from all of what they started saying at the beginning. He declined on talking about which side this ruling is going to go, but he said after the ruling he will definitely have a press conference to speak to the ruling. Well, we'll be awaiting to attend that particular press conference. One of out of the most notable names there in the court, Senator McGill has departed the courtroom. So we are trying to give you more updates, trying to get in touch with our correspondent. The network issue is dealing with us, not in a pleasant way, but we have to keep trying to bring you information and put you on the spot. Cameras are not allowed in the court unless otherwise granted by the judge, you know, so we are outside. That's the best we can do. We have to come up with engineering means and measures to put you in the courtroom, even though we ourselves cannot be there with the cameras to bring you all of what is happening. This is not a trial. This is not a trial. It's just a ruling. The petitioners filed a motion to the court. They filed for the judge to quash the subpoena issued them by the Asset Recovery and Property Retrieval Task Force based on grounds that they lacked the jurisdiction. Now, the subpoena itself is not under question. It is not the subpoena that is under question. It is the issuance of the subpoena, whether or not the Asset Recovery and Property Retrieval Task Force has got the jurisdiction to do so. And by jurisdiction, meaning the authority, you know, to do so. Now, that is what is under question now. If the judge upholds the petitioner's request and say, yes, you know, I do agree with all of the laws and all of the arguments, reliance on the laws and precedents that, look, the Asset Recovery and Property Retrieval Task Force lacks the jurisdiction, he is going to rule in the petitioner's favor and quash the motion. If that is done, again, we're speaking of ifs, then what would be the next step by AREPT to, if this, will they still pursue going after the Clar Hope Foundation, because they've got the notion, they are of the belief that as per their mandate to recover assets, public assets that were privately converted, you know, to recover monies, to recover properties, and the rest that are meant to be public monies and properties that were misappropriated or misused, is part of their mandate. And so they are of the belief that the Clar Hope Foundation, through by extension the Clar City of Hope, used public monies to be established and donations to be constructed, has been using public monies and donations for its operation. That is the belief of the Asset Recovery and Property Retrieval Task Force. So that is now caused. They then issued a subpoena to BMC, Building Materials Corporation, the company that did construct the Clar City of Hope, you know, to provide all of their documents, all of their receipts, all of their construction contracts, all of their invoices. According to what we've gathered from the court, BMC obliged. They also subpoenaed the Rural Renewable Energies. They subpoenaed another company to provide information. According to what we've gathered from the court, is that these are all in line with a chain of investigation. So let's go back and see if we can get more updates. Sadly, we're not getting updates coming in as we speak. We are not getting updates as we speak, which is one of our foremost reasons for being here. We'll see if we can try and use another means of getting you updates. Give me a minute, folks. Let me step away for a minute. My colleagues will be keeping you
So we are still here at the Temple of Justice in Monrovia, where the Supreme Court of Liberia is ruling into a case involving the Clar Hope Foundation, an institution owned by the former First Lady of the Republic of Liberia, Madam Clar Maria, and that case is involving the foundation and the asset recovery and property retrieval task force. And so the judge, Roosevelt Zerwidi, is providing the ruling into that case today here at Criminal Court A at the Temple of Justice in Monrovia. This is Gabriel Bar. I'm here with the entire crew, and together we're going to bring you up to speed with major developments here today at the grounds of the Temple of Justice. You listen to Diamond providing you updates from the courtroom, and in there we have our judicial reporter Melvin Jackson, who is covering that ruling, and he's providing updates to the team out here. And as the update comes, Diamond going to bring you up to speed with them. So currently the atmosphere here is cool. It's not as compared to the one we observed during the case involving Prophet Key and the Chief Justice of Liberia, Yami Bweze. So though they are not the same case, but they involve public figure, people connected to political individuals. The former first lady is the wife of the former President George Weah, who is a political figure in Liberia. So people expected this place to be jammed with supporters of the Coalition for Democratic Change of former President George Weah, but this is not the case. The grounds of the Temple of Justice is cool, and people are just moving about their normal basic. But howbeit, we are still here, and we will update you as we get updates from the court room where the ruling is being held right now at the Temple of Justice. So just taking a story with us, Spoon TV is still live here at the Temple of Justice in Monrovia. Where justice must be done to all, as the slogan of the Temple of Justice in Monrovia. This is the look of the current look of the Temple of Justice. Everything is at normal here. There is no tension, there is no battle cry, there is no political thing here in defense of the former president's wife foundation. So folks, we are still here, Spoon TV, live from the Temple of Justice in Monrovia, and we are here to bring you updates in the case involving the asset recovery team and the Clar Hope Foundation of former First Lady Clar Maria. Currently, the lawyers of the both parties are in the courtroom defending their side, and we have Melvin Jackson, who is our judicial reporter there, and he's providing our updates as the ruling unfolds. So keep posted, stick and stay with us. Don't you go away as we do our best to inform you as relate to this case here at the Temple of Justice. So the presiding judge is expected to determine the next course of action as the ruling unfolds here at the Temple of Justice in Monrovia. A few minutes ago, we listened to the one of the senators of Magibi County, who was the Minister of State for Presidential Affairs during the administration of former President George Weah, Nathaniel McGill. He was also in the courtroom, and when he came out, questions were posed to him about his thought on this case, and the senator said he cannot provide or cannot say anything about this case right now, though he came to witness the matter, but he cannot say anything as it is a judicial matter. So he will speak to this case later after the ruling is being announced. So this is Spoon TV from the Temple of Justice. My name is Gabriel Bar. I'm here with Damon Slanko Johasi Joe and Emmanuel Phillips, and together we are bringing you updates from the case involving the Clar Hope Foundation situated in Marshall and the asset recovery team, the task force that was funded by President Joseph Boakai through executive order to investigate and retrieve government asset, government resources used by former government officials to acquire wealth or properties. So other updates from the court, you listened to Diamond, he read that earlier from the court. The resident that's presiding judge, Roosevelt Zerwedi, required to the foundation, that's the Clar Hope Foundation, to provide legal documents related to its funding and construction. So the court is expecting records of funds received from individuals, government institutions, and international partners that led to the construction of the Clar Hope Foundation there in Marshall, because earlier the former president said she got money from international partners, donors that funded the construction of that area. And so the court is requesting documents, financial documents relating to funds that were generated to construct that foundation there in Marshall City, Margibi County.
We apologize for the brief moment of quiet. That's due to the fact that we were doing our best to give you back the updates from the court. So the ruling is very long. According to our judicial correspondent, the judge has been reading for close to an hour and a half. He started reading the ruling from 10:30 a.m. this morning. It's already after 12 midday, 11 minutes after 12 midday. And what we've been informed of is that the ruling is very long, and we should wait for the conclusion. But however, howbeit, we're doing our best to bring you real-time updates. So the important, I know someone will say everything the judge says is going to be important, but the important of the important ones, we will be updating you about that as well, because we are getting some messages coming in from our correspondents in the court, in criminal court A here at the Temple of Justice. So once the judge has denied the motion, that is the breaking news. The breaking news is the judge has denied the motion filed by the Clar Hope Foundation, the petition filed by the Clar Hope Foundation, that Judge Roosevelt Willie quashes the subpoena that was served on them. The judge said he has ordered the Clar Foundation to produce all of the documents. So the breaking news is Judge Roosevelt Willie has denied the petitioner's motion to quash the subpoena. What we can tell you is the judge has said the Clar Hope Foundation must provide all of the documents, and it is overdue. They are to provide the documents in 1 week. That is the breaking news coming out of Criminal Court A, that Judge Roosevelt Willie has denied the petitioner's request for a motion to quash the subpoena served them by the Asset Recovery and Property Retrieval Task Force. In fact, the judge has mandated the Clar Hope Foundation to provide all of the documents in 1 week. So, ladies and gentlemen, that is what is coming out of Criminal Court A. According to our correspondents in the court, the judge has finally ruled in that petition. He has denied the petitioner's request and has upheld the legality and the jurisdiction of the asset recovery. So Judge Willie has said the Clar Hope Foundation must provide all of the documents. In fact, that their refusal to provide these documents has been long overdue, and they should provide all of the documents. These documents include list of donors, financial transactions, everything that has got to do with the establishment of the Clar Hope Foundation, the construction of the Clar City of Hope, and the operations of the Clar City of Hope. So the judge has accepted an appeal. The petitioners have taken an appeal to the Supreme Court of Liberia. So even though the judge has
giving Adam this before